Hello, 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 everybody. Happy marvelous Monday. I hope that you are well. I'm so excited that you are joining me today. I'm Carissa Span, the landlord and tenant coach, and today's discussion is all about landlord and tenant myths. Um, my only goal today is to share information to make sure that it's clear, it's relevant, and it's understandable. So let me just say thank you so much for tuning in. Thank you for watching on Facebook, on LinkedIn, as well as YouTube. I do have a special guest who's joining me today. He's no stranger. He's been here before. He's none other than Keith Childs. And we're just going to go through some common myths, misconceptions in the rental community. So if you have any comments, if you have questions, we are here to answer your questions today. I'm super excited. So last week we talked about myths as pertains to the tenant screening process for landlords. Well, today I wanted to bring back and just add some more value. So if you are a landlord, if you are a tenant, this segment today is for you. Let me know where you're watching from. I love to know where you're tuning from, your geographical locations. If you have not subscribed to my YouTube channel, why don't you go over to the YouTube page, smash that subscribe button so that you'll be the first to know when I am live and online. So let me bring on my special guest because I'm excited to get into the discussion today. I received your emails, your questions that you have, and so we are going to touch on those and more. All right, so excuse me for 1 second. Let me invite my co-host, my partner, none other than Keith Childs.
Hello, hello.
Hey, Keith.
Hey, Chris, what's going on? Happy
Happy
Monday.
Monday. Happy Monday, partner.
Happy Monday. Happy Monday.
Listen, Listen, Keith, I'm excited. I'm glad that you're joining me today. I'm going to try to get through it. Listen, it's allergy season, so my eyes are a little swollen. So I'm going to try to get through it. Any,
Right.
any seasonal allergy sufferers, you already understand. Please just bear with me tonight. But Keith, listen, I'm excited that you're here. We're talking about the 5 myths for landlords and tenants. But before we get into the discussion, Keith, I want you to just introduce yourself. Tell the people who you are. I want them to know a little bit more about you before we get into the discussion today.
Absolutely. I appreciate it. Hello, everyone, viewers. My name is Keith Childs. I am a landlord, housing manager. Exactly my title right now. I've been in property management for a little over 25 years. All aspects of it lead me right back to the roles of I'm currently a landlord now, as housing manager. So just joining this, being a part of this platform is just been I'm delighted to do because Carissa has such a strong platform for landlords and tenants and whoever else that want to listen and learn some stuff. I'm always learning on here. I mean, even though I've been in this business for over 25 years, I learn every day. That's why I love coming on this platform, and I'm always excited when I get the invite with my partner, want me to come on, and I'm able to jump on and let's rock and roll. Let's have some fun today and learn some, try to tackle some of these myths that's out here about landlords, rentals and tenants and all the good stuff and have fun doing it and then sit back and enjoy ourselves. And I'm ready to rock, Chris. Let's take it away.
All right. Thanks so much, Keith. So I see Christina. She said, good evening. Keith, she's tuned in from Washington, D.C. She said, good evening, Mr. Childs.
Good evening, Christina. Good
All right.
evening.
So Keith, I know we are going to have a dynamic show today as we are talking about the 5 myths for landlords and tenants. Here's what I do want people to know, Keith, is that we're not sharing any legal advice today. We are just sharing information, which is the best practices for the industry. So if you are a landlord, you have questions, drop it in the comment section. If you are a tenant and you have questions, we want to hear from you. All right. So feel free to just jump in, chime in if you have questions along the way. If you have information that you want to add, just go ahead and feel free to do that. So, Keith, here's what I want people to know about the rental property that they may be managing, right? The the most common thing that people always hear me say is this: Keith, is the laws are different, right? Depending on the jurisdiction.
Yes.
And so from one city, from one state, from one jurisdiction to the next, things are not always going to be the same. So the laws are different, and that will obviously require landlords to tweak their business practice, if you will, right? So, Keith, one of the biggest misconceptions in the rental community that I've seen is that, and that's the first one here. Let's talk about this, if you will. Landlords can evict for no reason.
In which landlords can evict for no reason. Ah, not true.
Yeah,
I,
that's definitely a myth. But what's your take on that, Keith?
well, it all depends. It's coming from and a lot of this stuff, and I was smiling when you sent these questions over to me because I said I've heard these throughout my time, my tenure as a property manager, and a lot of this is why another reason I enjoy your platform is because this is a lot of misinformation. People think this. Landlords can evict for no reason. Well, no. It has to be a reason for landlords to evict. They just can't evict for no reason. Um, it has to be a reason for them to evict. That gotta be stipulated and followed, backed up in at least. So that is a myth buster. Um, Finish from my opinion, and you can add in, Chris, and correct me if I'm wrong. But I don't think that a landlord can evict just for no reason. You can't just wake up and be like, oh, you know what? I'm gonna evict that tenant over in apartment 101. It don't work that way. So there's steps and protocols that we have to follow as landlords, and it's a whole ordeal. Even to get evictions in where I'm from. It's a whole process to do an eviction. But to evict for no reason, I don't think that's true. What do you say, Ms. Chris?
That's definitely not true. That is false. That is a misconception. And I believe, Keith, that this may have started or stemmed from landlords who may not be as knowledgeable about running um, just a foolproof rental business,
Right.
right? And so Keith, I say if you treat it like a business, it's going to pay you like a business. If you treat it like a hobby, it's going to pay you like a hobby. And sometimes landlords, when they are not educated and maybe they are just getting into property management or just getting into real estate investing, they don't really understand the laws. They don't have that they don't have that background that
Right.
will guide them. And so they seem to think that because it's their property, they paid money for it, they own the building or the house, the condo, or whatever, that they could just evict tenants for no reason. Keith, over the years, I've worked with many of landlords as I've managed property. Um, I've been in property management in some sort of capacity for almost 30 years. And I have had people, owners, colleagues of mine, investors, they felt that they could just kick a tenant out because they
Right.
didn't like the tenant. Maybe it was a tenant from hell, which is something that I've talked about in the past. And let me just say that we're not bashing tenants, we're not bashing landlords, but we're just sharing in, and we're just just having this conversation, right? But I've seen where owners, they seem to think that because the tenant may not be what they desire, that they could just kick them out for no reason. And I'm sure, Keith, you heard horror stories. You
Mhm.
are familiar with horror stories of landlords
Oh,
evicting tenants or trying to evict tenants for no reason. But the truth is that you do need a reason to evict your tenant. So if you're a landlord, if you're a property management um, professional, you do need a reason to evict the tenants. And it will just depend on what the laws are. It also depends on what's in the lease. But most of the common reasons may be a breach of lease, if there's some sort of lease violation or continuous lease violation for non payment of rent, and in some cases, an expired lease. So, Keith, we know in DC and in places where the lease automatically go or convert to month after that initial lease term is up, there are some places where you have to renew the lease, right?
mhm.
Or the laws allow owners to renew the lease. And if the lease is expired, they could terminate the tenancy. Well, again, there must be a reason to evict the tenant.
Yeah,
Uh,
and to add to that, it's hard enough to evict a tenant with a reason. So for no reason, it's damn near impossible. Well, it's not going to happen, but it's hard enough to evict with a reason. So yeah, so just think about, you gotta, just back to what you always say, your lease and everything got to back it up, and you got to represent what you're going for. Because as we know, as landlords, going to court with a tenant or for a tenant, uh, to try to get your property back in possession of your property, or get your, try to gain possession back of your property. I'm sorry. It's just it can be a nightmare, if you don't have all your I's dotted, your T's crossed, and it can be a lot. So, and I know I've been a part of people staying in tenants staying in properties for almost close to 2 years with no rent, and just imagine, that sting of staying in the properties and not paying, and you have to, somebody got to pay that mortgage, and your tenant not paying you. So yeah, so you want to make sure that you, one, and you said, we talked about something you said before we go to the next one, Chris. One thing is, just because you own a property, and this is big, because you own a property as an investor, and you may be a very good investor, you may have little to no knowledge as a landlord, and those got to work hand in hand. So they don't. A lot of investors, some investors, don't seem to think so. They think, oh, because I'm savvy enough to get properties, they know how to get properties, but taking care of the property on the other end, because we are a revenue-driven entity, you need to know how to manage. You need someone to understand the laws, and you need to take care of those tenants so you can continually get paid and not have all the issues compound. So I just wanted to throw that in as a little caveat. But yeah, you definitely want to make sure that you're doing all those things.
those are some good points. Thank you for that, Keith. Hey, Lynn. Lynn, she posted a comment. She said, "Good evening," and document, document, document.
Absolutely. Yeah, she understands. Documentation.
Listen, documentation beats conversation any day. All right. So here's the second thing that I want to touch on today, Keith, and that's this. I've heard some owners say having a tenant is better than having no tenant at all.
Let's elaborate on that. That's interesting. What perspective? Share that with. I read that and I kind of smiled a little bit, because what angle would that? What would it mean by that? Like, having a tenant is better than having no tenant at all. Because that can be untrue. Sometimes you can have a tenant that you wish you didn't have no tenants. So I don't know if it's always having a tenant. I think they're probably looking, and I don't know, from a perspective of, well, at least we getting rent, I think. But just imagine it's a market tenant that you're not getting rent. Imagine it's a housing tenant that you're not getting rent, or a tenant from hell, as we say. So I don't know. What would you say? Is that a true or false? Man, that's kind of, I'm kind of half and half with that one, depending on what perspective it's coming from. What do you think?
So here's the thing, Keith, and you probably heard me say over the years that bricks and mortars don't pay rent, and I'm sure that a lot of landlords will agree, meaning that vacant property don't put money in the bank, right? You can't, if you have a vacant property with no tenant in place, you're not going to receive any income. And
Mm-hmm.
so some landlords, Keith, they feel that they should just have any tenant, right?
Mm-hmm.
And usually when that happens, um, maybe a landlord, they're having a rough time, they have maybe a financial hardship where they're hard pressed to get a tenant in place. And sometimes when that happens, they're rushing to just get anybody in there.
Raw
So
money.
absolutely, because they want the money. So I shared how in my earlier years when I was managing property full time with my property management business that I had in operation, I came across an investor, and he had no desire to do background checks, no background screening for anybody, right? And so he was just so desperate to find tenants, and so he allowed the goal was to get one tenant in place, take that money that was coming in to use it towards repairs for the second unit, just keep, because he had an empty building. The,
Mm-hmm.
I mean, the entire block was plagued with crime and drugs, all types of activity that was going on. So he was just hard pressed to get a tenant in place. So no background checks, no screening in place. He told the people that came in, listen, don't worry about the background check. He didn't even have them to do an application. And, I tried to advise them, he was an older couple. And I said, listen, I don't think you really want to do that, because at the very least, you want to have them to complete an application. Even if you don't go through the background check, conducting, verification of income, credit, criminal, all that stuff, the stuff that we do, right, Keith? So although I advised him to not go down that rabbit hole, he chose to anyway. And so he got a tenant in place. He had to end up taking this tenant to court. And I felt so bad for him as well as the tenant, because he didn't have the money to make repairs. The tenant stopped paying rent. He didn't have enough information to take this tenant to court. And
Yeah.
so it could be true that, having a tenant in place is better than having none at all. But worst case scenario, you have the wrong tenant in place. That could
Right.
cost you more money. And so that could be a myth, but I'm with you on that 50-50. So I'm gonna let you
Right.
chime in on that with what I shared, Keith.
Yeah, no, I concur, and I'm sitting here thinking, like, you have to look at it from I would look at it from a business perspective, in a sense of, do your checks and balances. What do it cost you to turn a unit? What do it cost you in lost rent? So you have to really do a comparison, do a spreadsheet, and see if I have to evict the tenant, which is, pay an attorney, landlord, those fees add up. I think last time I did one was like almost close to 10 grand to almost evict the tenant plus landlord fees and remodel an apartment, or repaint the apartment, repaint the turn apartment over. Um, when you look at it like that, I'm thinking about, for the worst case scenarios, is it better to have a tenant and no tenant? No, because, and I also understand that if you at that position and you need a tenant, and that desperation sets in for a investor or a landlord, whoever, owning the unit, they start to feel like, hey, these bills are piling up. It's best, as you were saying, to get somebody in here, but you don't ever want to put a tenant, excuse me, in your unit without documentation. Just like the young lady Lynn said, you want to document. You want to make sure, because how are you protecting your assets? How are you protecting yourself when that time comes to evict? You don't have no social security on them. You ain't got no information on them. You just move them in hopes they pay their rent. And if they get in and don't pay their rent, and if they stay there for a certain amount of time, they become squatters, and it's really hard to get them out. So, and yeah, that practice I wouldn't tell nobody ever do. Don't care how desperate you are. Do an application fee on them. Do an application on them. Get their social security. Get stuff so you can tie back to them. So find that out. Definitely want to do that.
Absolutely, Lynn. Thank you for your comment. Lynn said, take Carissa's class. It's a wealth of information. I appreciate that, Lynn.
Mm-hmm.
And that was some good feedback. I really like the points that you touched on. So Keith, here's the third thing that I want us to talk about. I'm gonna
Okay.
share this information. A lease is always legally binding. A lease is always legally binding. So for those of you who are watching, whether you're a landlord or a tenant, um, do you believe that a lease is always legally binding? Let me see your comments. All right. Let me acknowledge some people who are here. Hey, Antoine, thank you so much for tuning in. Um, Antoine, your question is, how do you treat tenants who move in and then later say they have a need for an emotional support animal, even though the lease says no pets? That's a great question. I'm gonna come back to that question. Um, so Christina, you said yes, a lease is always legally binding. Lynn said if it's signed, probably. Um, hey, Terrence McCrimmon, thank you so much for tuning in. You said yes, a lease is always legally binding. Hey, Vic, you said if it's signed, yes. So the question is a lease always legally binding? So let let us let's answer this question for Antoine, and then we're going to come back to this. Hey, Moose, thank you for tuning in. Moose said, yes, a lease is always legally binding. I love it. I love the feedback. I love the responses. So Antoine, he's an investor. Keith, not sure if you know him. Big investor in the East Coast. He's doing a lot in the East Coast. I've been watching him. He's a shaker. He's a mover and a shaker all along the East Coast. So thanks for tuning in, Antoine. So how do you handle a tenant moves in, they sign the lease acknowledging that they don't have pets, but then they say, oh, well, I need an emotional support animal?
You're asking that? I'm saying so because I deal with that all the time. So do you want to?
I'll let you respond today. Go ahead, Keith.
It's simple. I mean, it's one because how the laws are written. Emotional animals with documentation can't be discriminated against. So if you get a facility that says no pets, but you cannot say the no pet policy don't apply to emotional animals, but emotional animals must have proper documentation from a certified physician. Because people will say, "Hey, that's my emotional animal, my emotional pet," and they got something that from the doctors or a physician that stipulates that they need this for an emotional some type of therapy, then by all means you can charge a pet fee, and you cannot, and I will do not deny them, because then you put yourself in a discrimination lawsuit or posture. They move the animal in after the fact and then presented the letter. Um, right.
Have you experienced that, Keith?
I have, yeah, I have. People, because that's just a backdoor way of someone trying to speak out. But if they have a letter and it's presented, and you're seeing the letter, and it worked out. I mean, it is like, hey, it's official. Then unfortunately, you don't want an animal at that property, but it is emotional. You can't say, because then you put yourself in jeopardy of being sued for discrimination. Because these animals got rights now, like humans. Especially when it's coming from that side of emotional animal. But I do understand what you're saying, because you have some properties where you say you don't want any pets, zero pets, and but I wouldn't go down that road to say we don't want any emotional pets, because I think you put yourself in a pickle.
So let me chime in for a second. Now, if it's a pet, that's one thing, but if it's an emotional support animal or service animal, if you hear those terms, just kind of think like, okay, if it's an animal versus a pet, we know that they'll, like you said, they'll try to backdoor situation where they sign the lease agreeing to not have any pets. But if there's an emotional support animal or if there's a service animal, they must have some sort of documentation from the service provider, medical service provider. But then also, if there is an emotional support or service animal, you still, as a housing provider, you can require vet shots and records, because you want to make sure that it's not just an animal from off the street, right? You still need to collect information from the tenant. So just follow up with the letter in writing and say, hey, we received your request for a service animal. Please provide documentation from your physician. But see, here's the thing, Keith, it doesn't have to be a doctor. Listen, you can go online right now, and tenants can find a letter online, right? They can pay for this stuff, but because there's not really like a standard universal law on how to handle this, this is why I tell landlords, listen, collect information, get the vet records. I had one young lady, she reached out to me. She said, Carissa, not only did this tenant move in, like Antoine just shared, not only did the tenant sign the lease agreeing to no pets, they moved in, provided a letter, and when this young lady went to the property, the tenant had 5 animals at the property. And so obviously there was a violation. There were some shady things going on. And I just gave her tips on how to handle the situation. It worked out. Where's the tenant? The landlord gave the tenant a letter, released them out of the lease, and the tenant moved on to something better. And that was an easy fix, but sometimes it doesn't always work out like that. But thank you for that question, Antoine, and thank you for responding, Keith. So we are talking about a lease. Is it always legally binding? And so far, I've heard everybody say yes. All right. All the comments that have come in, everybody says yes. That is a myth. A lease is not always legally binding. All right. But here's another comment. Christina said, when it comes to a verbal lease, it can be hard to prove the lease terms. That's a good point. I like that. She said, when it comes to a verbal lease, from my understanding, correct me if I'm wrong, but it can be hard to prove in court. Always have it in writing. That's a good point. But see, here's the thing, because when it comes to a lease, and although it could be in writing, and although the tenant agree to the terms of the lease, it must be um, it must be lawful. So, Keith, we can sign an agreement to say, I'm gonna give you extra money because I'm not even gonna put out any no, I'm gonna put a hypothetical. I'm gonna put an actual out there because I know that it's happened where in writing, a landlord, obviously, Lynn, they didn't take my class. They didn't watch these free Facebook, YouTube, LinkedIn lives that I do every week. But they actually put in their lease that they would exchange sex for rent payment. It was in writing. The landlord put it in the lease and the tenant agreed to it. And for whatever reason,
What?
people will do some unthinkable, some unimaginable things. It has to be lawful. And just because you create a lease and a tenant sign it, if it goes against the law, it does not matter, because if it goes to the court, if it goes before the judge will not uphold something that is unlawful. So that's what makes that 50-50. That could be false. A lease is not always legally binding. Keith, I'm gonna let you respond to that.
Yeah, well, definitely. I mean, that I was looking at all the answers coming in, and it's because just thinking about it, it sounds like yes, because at least it's a contract that it would seem to be legally binding. But there are some exceptions to the rules, like the wording in the lease, and even this, I've seen situations where parties have signed lease and the judge has still not may allow them out of that lease for whatever reason. It all depends. That was like a case by case situations. That when people come in and say, "Hey, it's the lease," it is only because you would think as landlords and investors that if you sign this, that it's binding. Because I will always say, and I always point back to you, Carissa, put it in the lease. You know, hold them to because that's really all the protection we have is when we go to court. So if you get to court and you got your lease, and then you hear that, oh, it's a loophole that you can't get out. So not, I mean, sad to say, it's not 100% binding. You may get a high percentage, but is there some? If you get some people that's savvy enough to break that lease down to attorney, you may be looking at some stuff that I've seen people myself sit in the court thinking you got all your documents right, and they still wiggle out of it. So yeah. And let me just jump back. Let me switch. I was reading something here while we're talking to about this animal real quick, and it's and this is very good to understand for those who may not know. I'm reading here the myth, since we're talking about myth, the myth that an emotional support animal can be treated differently than a service animal. I've heard it so many times that, oh, emotional support animal can be treated differently than a service animal, right? Unlike service animals are not required to perform a specific task. So this is why people think there's a difference. But the truth is, it says this is underlying this is understanding I mean this understanding I'm sorry this understanding is incorrect and can put you on the end of a losing discrimination lawsuit if you don't follow the correct procedures. So if you're a landlord or investor and you're out there thinking, oh well, a service animal we can treat different than an emotion, no you can't. And it says big as day, you cannot charge a pet deposit or any other fee for emotional support animals. So basically, if they say they got emotion, they got the right documentation, you can't charge pet fees. And you can have stuff line where you want to get their shot records and all that, but you can't charge a fee. And And the question though, Kristen, is a limit. Can we put a limit on support animal? I didn't read anything that said, because can you say, hey, you can only have one? Can it be a certain size on an animal? Do we have those rights? Say I don't want it over 20 pounds. You know what I'm saying? I don't want it big. Because people come and say, I need a support animal, and they bring a horse in your house. They have a horse travel right through there. I've seen them bring birds and ostriches and llamas. So, where do you draw the line? I mean, that's the question. But I don't.
So let me go back to my statement where I said that there is no universal guidance on this. An emotional support animal is but let me just also define the difference between the two. A service animal is usually a dog. It's trained. Okay. A service animal is required to, say, for instance, you have a tenant who may have seizures or something, right? That service dog is trained to maybe nudge up against the tenant's leg or to do something to aid. In a medical emergency. Now, an emotional support animal, it could be a dog, it could be a guinea pig, it could be a llama, it could be a unicorn, right? There is not like one category of animals. So I don't want people to think that it's just a dog or just a cat. It could be a snake, it could be a lizard. There is no universal law or guidance on that. And so I'm happy to bring back a young lady who specializes in this topic. I've had her on before, and she's very good. She breaks it down so that people can understand it. And unfortunately, if like you said, Keith, if a tenant has that documentation, right, it's not really much that you can do. So can you put a weight restriction on it, right? But keep in mind, it doesn't have to be a dog. It could be
Right.
it could be a giraffe, you know?
Right.
So, I just wanted to clear that up so people will understand that.
Right. And I
Right.
know it, and I understand a little bit. I feel the gentleman question and pain because as a landlord, I'm dealing with a lot of that now where tenants I'm going through and doing inspections and found everybody got a dog that shouldn't have a dog, and everybody's saying it's a support dog. It's an emotional dog. So that that's been a loophole for people that want to have dogs. I don't know how 2 and 3 pit bulls is support dogs. And not that I'm singling out pit bulls, but it seems like every of my properties, everybody just want a pit bull. So and especially in a community where you shouldn't have dogs. So yeah, it got to be some type of protection, or we got to have. It's nothing in place. We got to have some more protection for landlords and properties, because the dog thing, especially when COVID really hit, the dog thing went out the roof. Everybody went aboard a dog, 2 and 3 dogs. Everybody had to have 2 and 3 dogs once COVID hit. So you know that's really if you got a property where it not is not dog friendly, the way around people is go get those letters. Like you said, it don't have to be a physician. And can you challenge the letter? That's the question I like to ask someone who really understands it. Is there any way that a landlord can challenge it, for support without being, discriminatory?
Now, you can confirm the source, right? But you can never ask, and I'm glad that you brought that up. I didn't think to share this because this is not really the topic of tonight, but landlords cannot ask what the disability is. They cannot ask for a tenant to prove what the disability is. If they get something in writing saying that they are disabled and they get something from their medical provider, medical service provider, or whatever, landlords can ask for the they want to verify the source. They want to make sure that it's coming from a legit person versus paying for these letters online. So a landlord can ask for that information. They can confirm with the physician, the doctor, whoever wrote the letter. As long as landlords understand, they can't. Please never ask a tenant what their disability is, because a disability can be either a physical or a mental impairment. And so
Yeah.
just because a person does not look disabled doesn't mean that they're not disabled.
Yeah.
And please, and we're going to move on to the next one. And please, landlords, never refer to a disability as a handicap. Okay. People are disabled. And again, it could be physical and it could be mental. So, Keith, a lot of people don't know that technically and legally I am disabled, but I don't say that. I have
Mm.
plates and screws in my right foot, but I still ride my motorcycle. I can still walk and do all the things that I enjoy doing in life. It's just that I might have to take my time, you know.
Well,
Um,
yours is not disabled. You're bionic. You're bionic. So we don't call you the bionic. We don't call you $6 million woman. You're bionic.
and so, you know, people have challenged me like, it was a time I pulled up at a handicap spot and, you know, I have a handicap decal and all of that, right? Because like I said, I am just disabled. I just don't claim it, right? So anyway, this young lady, she challenged me. She says, "You're not disabled. You don't have a wheelchair." And I just looked at her and said, and I'm thinking to myself, like the ignorance of people. And not that I was calling her ignorant. It's not that I was belittling her, but keep a lot of people legit don't know that just because a person doesn't fit their mode of a handicap or a person being disabled doesn't mean that they're not disabled. And sometimes landlords will, and maybe that is a myth, maybe that's a misconception that just because a tenant doesn't look disabled, that they're not legally disabled. All
And
right.
most people, before we close out on that, most people just attribute this to being disabled to a wheelchair. You know, from the little wheelchair painting in the street and all that stuff. You don't, yeah, if you're not really in the wheelchair, they don't think that you're not disabled. But yeah, to your point, right? That don't mean that you're not disabled, but you're not in a wheelchair.
That's so true. Hello, Murray Lou. Thank you so much for tuning in from the Philippines. I'm glad that you were able to join us today. All right, so we're going to go back to our discussion about a lease if it's legally bonded. Then we're going to go to the next one. Moose says my wife is disabled. My wife is disabled also. Then after 8 surgeries.
Mm-hmm.
Listen, I get it. Moose, does your wife still ride? Does your wife ride motorcycles? Moose is one of my brothers. He ride as well. So Keith, I'm gonna put this out here. Maybe I don't know. I don't know if I should, but I was out riding with. I think I was riding with my bestie. I'm not sure who I was riding my motorcycle with that day, and I pulled up. I completely forgot, but I pulled up and I parked in the handicap. I parked. It was an honest mistake because I'm used to like if I'm driving any of my vehicles, I always park in the handicap spot. So I was out riding my motorcycle and I parked in the handicap spot. And that didn't go too well for people who didn't they had no understanding like you
Right.
ride a
Oh,
motorcycle.
right. Yeah. Yeah.
So
That's almost like an oxymoron, but it works.
wow. Okay, so I see your comment, Moose. Thank you so much. Okay, so we talked about a lease. It's always legally binding. Terrence said that makes sense. Vic, he said, wow. Lady, she just gave this surprise look when I talked about some things that a landlord actually put in a lease. All right. So tonight we're talking about myths and misconceptions regarding landlords and tenants. So let me share the fourth one for this evening. And I want to talk about this, Keith, because it is important. And I think that this is helpful to have this dialogue, this feedback. Here's a fourth one. A landlord can change the lock on bad tenants. A landlord can change the lock on bad tenants.
Yeah. If I mean, okay, the short answer to that is, yeah, you can change it if you if if you don't want to lose your property. You better not change your lock without going through the proper channels. I know that emotionally, you think you can change it. You can get mad, and I've seen people do this. And always jokes aside, I've worked with people who actually thought that they can do that. And I had to tell them, like, you can't just, I don't care how wrong the tenant is, you can't change the lock on someone, um, even if they owe you rent. You cannot. You got to go through the proper channels to evict them. And people think that, oh no, they owe me money, they ain't paying me in a month or two, and I'm gonna change their locks. That's a myth. Do not change nobody locks without going through the proper channel, because you will be sued, Mr. and Mrs. Landlord, or Mr. and Mrs. Investor. You don't want to do that.
Absolutely. Absolutely. As a matter of fact, that's considered an illegal eviction.
Mm-hmm.
And so, Keith, I had a young lady. She was new in property management. This happened a few years back. Um, she changed the locks. Not only did she change the locks, but she actually had the contractor to put all the tenant stuff out.
Mm.
Now, let me tell you why she did that. So, she followed the tenant on social media. The tenant gave notice that she was going to move, right? But she had not turned in the keys, and the landlord had not taken her to court. But she saw on social media where the tenant had moved into a new place, um, showing pictures and everything. And so she just assumed that the tenant moved and had gone on. Like I said, she was new in property management. She was new in the industry. She obviously didn't listen to me enough, or maybe she didn't show up, to get this free information, right? But Keith, she got her contractor to put all that tenant stuff out.
Wow.
So the tenant came back and was like, "Hey, I want to get my stuff." And her position was, "You moved. You don't live here anymore. We got verification on Instagram that you moved into your new place, changed the law." I
Mm.
said, "No, you can't do that." I felt so bad for her. I don't know how it turned out. But that tenant um, had every right to sue that landlord.
Yeah. Yeah, that I got a myth I want to add on. While I know it wasn't part of it, but we talked about this the other day, and I want to actually throw it out to the audience and see if what they think, or what's their knowledge on this. Can you? What is the process on taking possession of your property after someone passes? Do you know the proper process to taking your property back over when someone dies? So that I've learned. I mean, again, I'm always learning. So, and I don't know if it's that way across the board, but I've learned that it's different than I thought. I've thought what I've been doing for the longest has been one way, but it seems that there's some different rules that I wasn't aware of. That it's not just simple. If even if someone passed away, and a family member give you the keys in certain areas and judges, you gotta there's different processes of getting that property back. Were you aware of that, Chris?
I was not aware. We had this conversation the other day. I'm going to respond, but let's look at some of the comments that are coming to Keith. Lynn said, "Yes, you have to go through probate." Christina said, "Death certificate from emergency contact, then court." Vic says, "Death certificate should be in place." Should be. Lady, are you still on? Very Lady Robinson, are you still on? I want you to chime in. Those of you who are landlords, I want you to chime in. So we're talking about a tenant passes away. A tenant is deceased. What do you do? Okay, lady, you're still on. So tenant passed away, lady, and the landlord want the property back. Do they have to evict? Do they have to go to the court? Or can they just change the lock, get rid of the stuff, and rent it out to the next tenant? So that's the conversation that Keith and I just had just when was that, Friday, last week?
Yeah, that's found it. Because I was always under the impression that if I got the keys, and I've made none of it before, to be honest. So I got the keys, and they turn the keys in, and we can get the family take what they want, and then we can clear the property out and get it. But I've since learned that you must actually evict a person that's dead. You got to literally go to court and evict them out before you rent the property. Because I have a couple of units that's just sitting on the file, just sitting on my books that people have passed in, and we can't do nothing with them until we actually go to court and evict them. Now that was pretty odd, but
Yep. Yep. Absolutely. And so death does not terminate tenancy.
wow.
So a landlord must go through the eviction process to terminate the tenancy. And I know that a lot of landlords don't know that.
I didn't know it. I ain't gonna lie.
Right. Right. So, because and if you haven't gone through that, and and if you don't know what the laws are, you've never experienced it, you don't know, right? So you've never experienced that. I know for me, I never experienced that. So that's not an area of knowledge that I was aware of, right? But this is true. Death does not terminate the tenancy.
Mhm. Okay.
So,
Yeah.
FYI, landlords, property managers, real estate investors, you got rental property, people pass away, you can't just change the lock and rent it to the next place because the tenant is deceased. You got to go
Mhm.
through the courts. So check the law. Let me just say, check the laws in your jurisdiction to confirm, right? Because you don't want to get yourself in any trouble. So always find out what the law says, just depending on that rental property. And Keith, we have people who are watching in different areas. We have people who are watching overseas. And so obviously all the laws are not going to be the same everywhere. So please check with an attorney. Please check the laws to know what you can and cannot do. But I'm glad that you brought this up, and I'm glad that you brought this to my attention, Keith.
Yeah. Thanks for the insight. Again, another good reading. I love the platform. You see the ticket document, the court, lease death certificate document, the letters from the next sponsor. Yeah.
All
Mm-hmm.
right. Very lady, she said you must go through the proper channels, find out if there are anyone listed as emergency contact. Absolutely. Lynn came back with a response, don't remove anything because there may be a will regarding their belonging. Oh, I'm so glad that you said that, Lynn. That is so true. So Keith, I talked about the young lady who did an illegal eviction on somebody that was alive. But now when a tenant passes away and, landlords trash stuff, listen, those items could be in a will.
Yeah. 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 Absolutely can. Absolutely can be.
You would go
Uh,
to court if there is no emergency contact. All
mhm.
right.
That's another. Yeah.
So
And
I'm glad we're having this discussion. Go ahead, Keith.
yeah, and I was just saying, I was just adding to this since we was on the eviction stuff. I'm telling a little fun, not a funny story, but a story because it wasn't funny. But I was remember a situation where a tenant, landlord, led evictions and evicted a tenant and evicted the wrong tenant. They had eviction was for 301, and it went to 310. And the 310 was a perfect tenant and paid all the stuff. It had nice furniture, and they put all the 310 stuff outside. And people ran through it, and people called her at work. And she came back from work to find people that rummaged through all her stuff, took her big screen TV, took all the stuff, and it was the wrong eviction. So, as a
Wow.
landlord, that was a nightmare. Yeah. So, you want to make sure that double checking and making sure stuff is right because that was a nightmare for that landlord.
I'm sure, and it should have been.
Yeah. So just you gotta be. See. Mm, oh, cool. You're welcome, Christine. So yeah, just those are the things that man, from a landlord side, you always got to double check and triple check because that was just it was an honest mistake. Got the numbers turned around backwards, but it wasn't too honest for the young lady who lost all of her stuff. You know.
Yeah. So here's what I tell landlords when it comes to an eviction: make sure that you double check the address. If it's an apartment building, double check the door number. I have gone, and one of the most challenging things for me in property management when I was in property management full time, Keith, were evictions. Like, I really have a heart for people, and it touched me when I had to evict families or tenants who had kids and seeing the kids stuff outside. Like, that touched me. But one of the things that I always tell landlords is this: even on the day of eviction, go to the property, make sure that it is the correct address. Even if there's not, sometimes it may not be a sticker number on the door, it may not be a physical number on the door. Get yourself a black Sharpie and write the apartment number on the door.
Yeah, because you want to double check. You That's the
You
worst things you can do. One of them is the landlord just put the wrong person out. Yeah, that's.
Yeah, yeah, and that has happened
Oh,
so frequently, more than people know.
more than people know. It's been a terrible mistake, but it's happened, you know. And the landlords are 100% at fault. You know, you
100% at fault. Absolutely. Absolutely. So this is a myth. A landlord can change the lock on bad tenants. Listen, Keith, I've heard some horror stories during the pandemic where, like you said, even if a tenant owes rent, the landlord cannot change the lock. But in the pandemic, and especially because of the pandemic, lots of tenants didn't pay rent. Maybe
yeah,
they didn't have money, they didn't have the resources, the funds, the availability for them to pay their rent, or maybe they just flat out chose not to, right? But we do know that tenants didn't pay the rent. And there were landlords who changed the lock because they wanted their rent money, their mortgage had to be paid on the property, utility bills, taxes had to be paid. And when a tenant doesn't pay rent, sometimes it does create a hardship for owners and landlords. And so some landlords, they took measures into their own hands and they changed the locks on tenants. But that's illegal. All right.
yeah, it's illegal. Yeah, they got a whiff of that moratorium, and when the tenants heard that, they nobody won't pay rent. They're like, oh, what moratorium? We ain't got to pay no rent. Oh, okay. They just thought that meant they could live free, you know. But that was not the answer. It was not true.
And so now we're starting to see, I'm following a lot of cases, a lot of states and cities where there are a lot of evictions happening throughout the country now because landlords are fed up. And it's heartbreaking because the tenants who applied for aid or rent relief, to get assistance to pay their back rent,
Mhm.
some of that funding has not come through and tenants are actually being evicted, although they've completed applications. So it's just kind of bad. It's heartbreaking for some, but for others who were the bad tenants, the outliers who just made it really, really bad.
Right.
Shame, 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 shame. Okay, so Keith, let's go
Mhm.
to the fifth and the final myth for today. All right. Landlords can enter the property at any time they want. I know some people feel the way that they feel about it, but before we touch on this, how many of you agree that landlords can enter the property anytime that they want? Let's see your feedback. Murray Lou, I saw your comment a little earlier. Let me go back to your comment, Murray Lou. So Murray Lou, she had a comment about riding my motorcycle. She said she saw me riding a motorcycle. Um, thanks, Mary Lou. Okay, so let's have you touch on that, Keith. Go ahead.
Landlords can enter the property anytime they want. I would say no, you cannot enter anytime you want. Now, in case of emergencies, um, I tell all my tenants, in case of emergencies, of course, we got to come in, but we try to give a 24 to 48-hour notice, depending upon what we need to enter for inspections or housekeeping or whatever. Always got to give a notice, and that's per your lease. But also in the lease, if there's an emergency, a fire, a water leak, then we will enter your property because we don't want damage to continue throughout the property and down to my other tenants. So in those cases, yes, we will enter without warning, but it is extreme cases that we will. But the majority, we must give them a notice. We must notify them that we enter their property. So that they can't just, the answer to that is right, of course. You can't just enter without, warning.
All right, so you see the comments that are coming in. False, nope. Christina said 24-hour notice. Moose said nope, must give notice. Christina is pretty much agreeing with what you said. Only if it's an emergency, if it's a welfare check. That's a good point as well. So thank you for that, Christina. Lynn says you must give adequate notice, usually 48-hour notice unless emergency. I'm glad that you mentioned 48-hour notice, Lynn. Now, just depending on where the area is, some states, some cities still say 24 hours, but the laws have changed because of the pandemic, requiring landlords to give at least
Or,
48-hour notice.
mhm.
So check the areas just to make sure. Keith,
Here's a,
I'm sure.
here's a good question. I'm sorry, you about to say something? Go ahead, Chris.
No, go ahead.
Here's a good question to ask. It was about what we think about entering units. Can a landlord force a tenant to get their unit exterminated? Can a tenant be forced to get exterminated? Say you want to exterminate your whole property, you're an apartment unit, and a tenant refuse. Can you force a tenant for extermination?
Okay, good question. So let me just understand before I respond. So you have property, you're exterminating the entire property, and maybe it's a tenant who maybe you think they're the source or maybe not. You want to make sure that you treat all the units, right? And so your question is, can you force the tenant to receive the pest control service?
Can you go in even though you put letters out and you say you want a mandatory extermination for everyone? Can you go in and exterminate even if the tenant refuse treatment?
Okay, and so I like your comment, Lynn. So here's my response to that. Um, and that's a good point. Lynn said it depends on if they have medical issues.
Hmm.
So let me address that. Then I'm gonna come back to my original response. So let's say, for instance, there is a tenant in place. They have some sort of medical issues, right? And the pest control treatment is chemicals, or maybe the household have kids, infants, if you will. They don't want the smell from the chemicals in there, right? And if this tenant says, listen, um, I would love for you to exterminate, but please don't use chemicals. Now, this could go a couple of ways.
Hmm.
I'm gonna start here and then I'm gonna just work my way back to my original response. So the landlord said, I'm sorry, the tenant says, well, listen, I don't want you to treat my place because I don't want the chemicals. And they flat out refuse. You have to honor that. Please honor that. Um,
Now, they what if okay, we get a pest control that don't use chemicals, but this tenant is the source of the infestation.
mhm. Okay, so let me go to the comments. I see the comments that are coming in. Christina
Mhm.
said, document every attempt so that when a tenant say the landlord is not in compliance, you have the date and the times of the attempts. That's a good point. Um, Now, Lynn said, have them to sign a waiver, get it in writing that they're refusing and why they are refusing. That's a good point. I'm gonna go through the comments and I'm gonna come back and I'm gonna answer the questions. And so, lady said, if they refuse service, you
You can't.
cannot. So, but here's the thing, Keith. Um, let's say it is pest control treatment, right? It's extermination. There are no chemicals. Maybe you just want to put glue traps down or whatever, right? Because there are
Mhm.
different type of things that pest control companies use. They can use gel, they use these baits, and they use glue traps. And there are so many different things. But if a tenant flat out refuses and they do not allow you to enter and they create more of a problem than anything, don't do it.
Mhm.
Now, I would also say look at what is in your lease, because Keith, my lease packages, I've talked about my lease packages, and they're like 61 pages long, and there are at least 2 or 3 pages that talks about well, now, Keith, everything is electronic, so it's no longer 61 physical pages. Um, but and we thank God for that.
Right. Good.
Um, but put it in writing and cover you to make it the tenant's responsibility to notify you if there is some sort of pest control issue. So when they realize that there's a problem, they should report that within 5 days, right? And if they don't report it, now people can do whatever they like. I'm gonna just tell you what I've put in my lease packages over the years when I was full-time property management, which I'm not. Um, but I put it in writing. I put it on a tenant that they're responsible for letting me know that there is some sort of issue. And if they don't, and if there is some sort of infestation, the tenant will ultimately be financially responsible for whatever the cost was to abate the problem. Now, infestation is defined as two or more mice, two or more roaches, two or more bed bugs. Infestation is defined as two or more. And so I put that responsibility on the tenant. Now, if the tenant refused and the tenant refused, and like Christina said, or was that Lynn? Both of them. Put it in writing. Document your attempts that you're trying to treat the unit. If you have to go to the court, go before the judge, you have your documentation, Your Honor. We sent out notices saying that we were going to treat the unit. Your Honor, here's our rental, here's our lease agreement showing that we provide pest control services. We come out quarterly, we come out monthly. Document your attempts, show the judge the lease, whereas the tenant is responsible. If it's in writing, you always want to have it in writing.
Hmm.
But great question. Lady said, that's right. Spell it out and don't just skim over the lease. Review it with them and advise that they read over their lease again. Absolutely. Because that's what good landlords and housing providers do. And that's what we are. But everybody don't do that, lady. Christina, Lynn, and Keith, that's not everybody's business practice. And so we're sharing this information. And thank you for bringing it up, Keith, because we want those of you who don't know to get this information. Share this with somebody else. If this information has helped you, whether you are a landlord or a tenant, please share it with people because it costs absolutely nothing to show up and get this information. All right, Keith, I'm gonna let you touch on this a little bit more. We're talking about landlords can enter the property at any time they want.
Right. Yeah. So just back to that. So we said we agreed. No, you cannot enter the property. You want to give 48-hour notice. I mean, it's real simple. Give as much notice as possible. If it could be for longer than 48, good. But only in the case of an emergency, an extreme emergency, fire, say, water leak. You know, of course, if it's a welfare check, things like that. You can go into the property as needed on that, for that basis. But this is a handful of them that you can go. But the majority, guys, just have a good practice, real simple. Give them 48-hour notice that you're going in. And this has been very helpful, guys. I just want to say this has been enlightening. I always learn something when I come on this podcast. I always learn something, Chris. I love it. No matter how long I've been doing this, I learned, and it's cool. And I enjoy the feedback because this is what we need, building a community of us landlords and investors and tenants that can come on here and learn and share about the rights and what we have. Again, I appreciate it as always.
Thank you so much, Keith. It's always a pleasure having you on. You are a wealth of resources and information. And guys, listen, this is what we do each and every Monday right here, 7:30 p.m. Eastern Standard Time. So whether you're on Facebook, whether you're on LinkedIn or YouTube, please make sure that you're tuning in each and every week. I promise every week, my goal is to share information that will help the entire rental community. So it's information for landlords, it's information for tenants, it's information for people who just desire to learn and grow. Maybe you're thinking about getting into property management, maybe you're thinking about getting real estate and maybe renting it out to somebody else. And whatever the scenario is, just be educated, be informed. If you have questions, feel free to jump on and ask your question. We had someone who jumped in today. They had a question that wasn't even pertaining to this topic. We are happy to answer those questions for you. If you want to email me, let me give you my email address. Let me put it up on the screen for you. And again, if you have not already subscribed to my YouTube channel, please do that so that you'll be able to get the alerts and the notifications when I'm live and I'm online. So this here is my email address. Email me topics that you want us to cover, and I will respond to your emails. My email address is going to be carissaspan@gmail.com. carissaspan@gmail.com. So Keith, I'm gonna let you give final remarks before we close out.
All right. But definitely just wanted to say, just reiterating what you're saying, Carissa, this is a very, very informative platform and I love it. I can't wait till Monday so we can get to this and talk about the stuff that we need to share because there's so much information and there's so much stuff that we go through as landlords that when we talk to each other and we kind of, as we call it, what they call it in church, a fellowship, so to speak, if we fellowship here. But this is a great platform, and I'm just always impressed by it, and I love it. So I look forward to next week. I got some stuff that I want to share with you offline that we can bring up because now, understanding my little new role, I have tons of tons of stuff I got to add and ask questions about, and I learn from it because there's certain things, like to say today I learned some stuff that I didn't know. I didn't know a whole about the depth. I mean, I was my practice in it was a little off. I thought you say they pass away, you just take the property. So knowing, but we hear other people, other colleagues who give you information. So this is a great platform. So I appreciate you as always. Thank you again for having me on, and I look forward to the next time I get an invite. I look forward to it.
All right, Keith, thank you so much. Keith, listen, you're going to be back Monday. Just make sure you're available next Monday, 7:30 p.m. I got another hot topic we're going to discuss, and I'm sure that landlords as well as tenants will appreciate it. Keith, I'll follow with you, and I do appreciate you, partner.
I appreciate you too. Thank you so much. Have a good night. Thank you.
All right, guys. So today we talked about the 5 myths, landlords and tenants. I shared 5 misconceptions. The first was that landlords can evict for no reason. That's absolutely false. I also shared today a second myth: having a tenant is better than having no tenant at all. That's absolutely false. It's better to have the right tenant in place. We touched on the lease is always a legally binding document. That could be true, but it's not always true. The word that makes this statement false is always. So as long as it's legal, then yes, but some things are not always legal, so that makes it unenforceable. We also talked about a landlord can change the locks at any time on bad tenants. Absolutely false. Landlords cannot change the locks on bad tenants. I don't care how bad of a tenant you may have. You may not agree with the behavior. Maybe they're not paying rent. Maybe they are tenants from hell. Not that all tenants are bad, but some are. That's just the reality of it. I've been in the industry for 30 years and nothing surprises me. And the fifth and final thing we talked about today was landlords can enter the property anytime that they want. That is absolutely false. Now, Keith Childs, my partner, he shared that there are exceptions to that rule. If it's an emergency, if it's a welfare check, you're checking on your loved ones, and the tenants' loved ones want you to check on them. Then in that case, yes. But outside of that, no, that's absolutely false. I hope that's something that we shared and talked about today was helpful. My time is up. I thank you for yours. Please make sure you are tuning in each and every Monday right here at 7:30 p.m. Eastern Standard Time. I look forward to sharing with you. And again, if you have questions, if you have comments, if you have subject matters that you would like for us to discuss, email me. Let me know what your concerns are. I'm happy to get the feedback. All right. So I will see you all next Monday right here at 7:30 p.m. Eastern Standard Time. Y'all be safe. Listen, it's allergy season. Okay. My eyes are red. My eyes are puffy. I was struggling to get through today. So those of you who are suffering from seasonal allergies, you feel my pain. All right. But again, guys, I look forward to seeing you all next week. I'm Carissa Spann, the landlord and tenant coach.